Anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and I'm going to cover that with you now. You'll have with you the verdict form in paper form. I'm going to go over it with you. I'm going to project it on the screen in just a minute. There are 7 separate verdict forms because there are 7 counts, one for each count. So you'll have separate ones, and each one needs to be completed. So let me go over those with you now. Should be coming up on the screen. There you go. All right, so let me cover with you first the verdict for count 1. The top part of each of these forms is known as the style of the case. It merely identifies this case, State of Florida versus James Terry Colley, Jr. So let me go over verdict count 1. It starts off, we, the jury, find the defendant James Terry Colley, Jr. as follows as to count 1 of the indictment. As you'll see in the italics, and wherever you see italics throughout this verdict form, those are instruction for you. And the italics here state, please choose only one as to count 1. Let me go over the choices for you with regards to count 1. Your first choice is guilty as charged of both first-degree premeditated murder and first-degree felony murder, contrary to Florida statute section 782.04, paren 1, paren A. If that's your verdict, you would check that box to the left. Your second choice is guilty as charged of only first-degree premeditated murder, contrary to Florida statute section 782.04, paren 1, paren A 1. If that's your verdict, you would check that line to the left. Your next choice is guilty as charged of only first-degree felony murder, contrary to Florida statute section 782.04, paren 1, paren A 2. And if that's your verdict, you would check the line to the left. Your next choice is guilty of the lesser included crime of second-degree murder, contrary to Florida statute 782.04, paren 2. If that's your verdict, you would check the line to the left. Now, as you will see in the italics, it says, if you find the defendant guilty of second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant, and please answer yes or no to each of the following. So if your verdict is guilty of the lesser included crime of second-degree murder, there are some additional questions for you to answer. Those questions are whether the defendant actually possessed a firearm, yes or no, whether the defendant discharged a firearm, yes or no, and whether the defendant caused great bodily harm or death upon Amanda Colley, yes or no. Your next choice is guilty of the lesser included crime of third-degree felony murder, contrary to Florida statute section 782.04, paren 4. If that's your verdict, you would check the line to the left. Again, if that's your verdict, there are additional questions for you to answer. As the italics state, if you find the defendant guilty of third-degree felony murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant, and it's the same 3 questions, actually possessed a firearm, yes or no, Discharged a firearm, yes or no. Inflicted great bodily harm or death upon Amanda Colley, yes or no. The next choice is guilty of the lesser included crime of manslaughter, contrary to Florida statute section 78207. If that's your verdict, you would check the line to the left. Again, if that's your verdict, there's additional instructions under the italics and an additional question to answer. If you find the defendant guilty of manslaughter, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant used a firearm or weapon, yes or no? And then the last choice is not guilty. If that's your verdict, you would check the line to the left. And then there's a place for the foreperson to sign and date the verdict. Let me now move on to the verdict form for count 2, which you'll see is nearly identical to the verdict form for count 1, but I'll go over that with you now. Starts off, we the jury find the defendant James Terry Colley Jr. as follows as to count 2 of the indictment. Again, in the italics it states, please choose only one as to count 2. These are your choices with regards to count 2. Your first choice is guilty as charged of both first-degree premeditated murder and first-degree felony murder, contrary to Florida statute section 78204, paren 1, paren A. If that's your verdict, you would check the line to the left. Your next choice is guilty as charged of only first-degree premeditated murder, contrary to Florida statute section 78204, paren 1, paren A1. If that's your verdict, you would check the line to the left. Your next choice is guilty as charged of only first-degree felony murder, contrary to Florida statute section 78204, paren 1, paren A2. If that's your verdict, you would check the line to the left. Your next choice is guilty of the lesser included crime of second-degree murder, contrary to Florida statute section 78204, paren 2. If that's your verdict, you would check the line to the left. And as with the verdict on count 1, there would be additional questions if that's your verdict on the lesser included crime of second-degree murder. And as it states in the italics, if you find the defendant guilty of second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Inflicted great bodily harm or death upon Lindy Dobbins, yes or no? Your next choice for count 2 of the indictment is as follows. Guilty of the lesser included crime of third-degree felony murder, contrary to Florida statutes, section 78204, paren 4. If that's your verdict, you would check the line to the left. And that has the same question as the preceding question. If you find the defendant guilty of third-degree felony murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Inflicted great bodily harm or death upon Lindy Dobbins, yes or no? Your next choice is guilty of the lesser included crime of manslaughter, contrary to Florida statutes, section 78207. If that's your verdict, you would check the line to the left. Again, there are italics with further instructions, and there is one additional thing to answer below that, if that's your verdict. If you find the defendant guilty of manslaughter, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant used a firearm or weapon, yes or no? And the last choice for count 2 of the indictment is not guilty. If that's your verdict, you would check the line to the left. And then the foreperson would sign and date the verdict form for count 2. Let's now move on to count 3, which starts out as follows. We, the jury, find the defendant James Terry Colley Jr. as follows as to count 3 of the indictment. Again, in the italics, you have the instruction to please choose only one as to count 3. Let me go over those choices with you. Your first choice is guilty as charged of the crime of attempted first-degree murder, contrary to Florida statutes section 78204, paren 1A and section 777.04. If that's your verdict, you would check the line to the left. There is a question below that, if that's your verdict for you to answer. The question in the italics reads as follows. If you find the defendant guilty of attempted first-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice is guilty of the lesser included crime of attempted second-degree murder contrary to Florida statutes in section 78204(2) and 777.04. If that's your verdict, you would check the line to the left. And again, if that's your verdict, you would have an additional questions to answer, which are as follows. If you find the defendant guilty of attempted second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice is guilty of the lesser included crime of attempted manslaughter by act contrary to Florida statutes section 78207 and 77704. If that's your verdict, you would check the line to the left, and if that's your verdict, there would be an additional question to answer, which is as follows. If you find the defendant guilty of manslaughter, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant used a firearm or weapon, yes or no? Your next choice is as follows. Guilty of the lesser included crime of attempted aggravated battery contrary to Florida statutes section 784.045 and 777.04. If that's your verdict, you would check the line to the left. And if that's your verdict, there's an additional question or questions to answer as follows. If you find the defendant guilty of attempted second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice is guilty of the lesser included crime of attempted battery contrary to Florida statutes sections 784.03 and 777.04. If that's your verdict, you would check the line to the left. And your last choice is not guilty. If that's your verdict, you would check the line to the left. And again, once the jury has reached its verdict as to that count, you would sign, the foreperson would sign a date the verdict form. Let's now move on to the verdict form for count 4 of the indictment. Cover that with you now. It starts off, we the jury find the defendant James Terry Colley Jr. as follows as to count 4 of the indictment. Again, in italics you have the same instruction. Please choose only one as to count 4. Your first choice is guilty as charged of the crime of attempted first-degree premeditated murder contrary to Florida statutes sections 78204(1)(a) and 777.04. If that's your verdict, you would check the line to the left. And if that's your verdict, you would answer the question right below that. If you find the defendant guilty of attempted first-degree premeditated murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice with regards to count 4 is guilty as charged of the crime of attempted felony murder, a enumerated felony contrary to Florida statutes section 782.051(1). If that's your verdict, you would check the line to the left. And if that's your verdict, you would answer the questions below that, which are as follows. If you find the defendant guilty of attempted felony murder, enumerated felony, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice is as follows. Guilty of the lesser included crime of attempted second-degree murder contrary to Florida statutes section 78204(2) and 777.04. If that's your verdict, you would check the line to the left. And again, if that's your verdict, there's an additional question with questions to answer, which are as follows. If you find the defendant guilty of attempted second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice with regards to that count is as follows. guilty as charged of the lesser included crime of attempted felony murder, non-enumerated felony, contrary to Florida statute section 782.051, paren 2. If that's your verdict, you would check the line to the left. And again, if that's your verdict, there's an additional question or questions for you to answer as follows. If you find the defendant guilty of attempted felony murder, non-enumerated felony, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice is guilty of the lesser included crime of attempted manslaughter by act, contrary to Florida statutes section 782.07 and 777.04. If that's your verdict, you would check the line.
Judge, I'm sorry to interrupt, but we've noticed a few typos that I need to bring to the court's attention, and you're about to get to a couple of them. Can we approach?
Sure. Excuse us for a moment, folks. Two choices on count 3. On the second page, starting with this, I guess is the third choice down on the second page of count 3. Again, the third choice is guilty of the lesser included crime of attempted manslaughter by act. It then reads in the italics, if you find the defendant guilty of manslaughter, that should say attempted manslaughter as opposed to manslaughter with regards to that particular count. Going down to the fourth choice. The fourth choice is guilty of the lesser included crime of attempted aggravated battery, contrary to Florida statutes. If that's your verdict, again, you would check the box. And the question below that, if you find the defendant guilty, it says of attempted second-degree murder, that should say attempted aggravated battery. So we'll fix those typos. They're going to be by hand. We'll fix those typos on the verdict forms that go back to you. Let me go back to count 4. I'm going to start over on count 4, and I'll point out some of the typos as well. It's the same typos on count 4. Verdict count 4 starts off, we the jury find the defendant James Terry Colley Jr. as follows as to count 4 of the indictment. Again, in the italics it states, please choose only one as to count 4. Your first choice, again, guilty as charged of the crime of attempted first-degree premeditated murder contrary to Florida statutes section 78204(1)A and 777.04. If that's your verdict, you would check that line to the left and you would answer the question below, which are as follows. If you find the defendant guilty of attempted first-degree premeditated murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your second choice with regards to count 4 of the indictment is guilty as charged of the crime of attempted felony murder, enumerated felony, contrary to Florida statutes, section 78205(1)(1). If that's your verdict, you would check the line to the left and then answer the question below, which is as follows. If you find the defendant guilty of attempted felony murder, enumerated felony, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? The next choice with regards to count 4 of the indictment is as follows. Guilty of the lesser included crime of attempted second-degree murder contrary to Florida statutes, section 78204(2) and 777.04. If that's your verdict, you would check the line to the left. And if that's your verdict, you would answer the following questions. If you find the defendant guilty of attempted second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice with regards to count 4 of the indictment is as follows. Guilty as charged of the lesser included crime of attempted felony murder, non-enumerated felony, contrary to Florida statutes section 78205(1)(2). If that's your verdict, you would check the line to the left and you would answer the next questions. If you find the defendant guilty of attempted felony murder, non-enumerated felony, do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next choice with regards to count 4 of the indictment is guilty of the lesser included crime of attempted manslaughter by act, contrary to Florida statutes sections 782.07 and 777.04. If that's your verdict, you would check the line to the left and you would answer the following question. I'll point out a typographical error in here. If you find the defendant guilty of, it should say attempted manslaughter there, and we'll make that correction on the verdict forms that you get. Do you also find beyond a reasonable doubt that during the commission of the offense, the defendant used a firearm, yes, used a firearm or weapon, yes or no? Your next choice with regards to count 4 of the indictment is as follows. Guilty of the lesser included crime of attempted aggravated battery, contrary to Florida statutes section 784.045 and 777.04. If that's your verdict, you would check the line to the left and you would answer the following questions. And again, there's a typo I'll point out to you here. If you find the defendant guilty of, it should say attempted aggravated battery rather than attempted second-degree murder there. Do you also find beyond a reasonable doubt that during the commission of the offense, the defendant actually possessed a firearm, yes or no? Discharged a firearm, yes or no? Your next option with regards to count 4 of the indictment is as follows. Guilty of the lesser included crime of attempted battery, contrary to Florida statutes sections 784.03 and 777.04. If that's your verdict, you would check the line to the left. And your last choice is not guilty. If that's your verdict, you would check the line to the left. And then again, the foreperson would date and sign the verdict. Let's now go on to the verdict for count 5, which starts out as follows. We, the jury, find the defendant, James Terry Colley Jr., as follows as to count 5 of the indictment. Again, in the italics, you'll see please choose only one as to count 5. Your first choice for count 5 is as follows. Guilty as charged of the crime of burglary contrary to Florida statutes, or Florida statute section 810.02, paren 1 and paren 2. If that's your verdict, you would check the line to the left, and if that's your verdict, there will be additional questions for you to answer below that, as you'll see in the italics. So if you find the defendant guilty of burglary, do you also find beyond a reasonable doubt any of the following circumstances? And you would need to answer each of these, yes or no, if that was your verdict as to count 5. The first one is the structure entered was a dwelling, yes or no. The next one was during the commission of the burglary, the defendant committed an assault or battery upon Amanda Colley or Lindy Dobbins, yes or no. The next one is during the commission of the burglary, the defendant actually possessed a firearm, yes or no. The next one is during the commission of the burglary, the defendant discharged a firearm, yes or no. The next one is during the commission of the burglary, the defendant inflicted great bodily harm or death upon Amanda Colley or Lindy Dobbins, yes or no. Your next choice with regards to count 5 of the indictment is guilty of the lesser included crime of trespass in a structure contrary to Florida statute section 810.08. If that's your verdict, you would check the line to the left, and there is an additional question under that if that's your verdict. If you find the defendant guilty of trespass in a structure, do you also find beyond a reasonable doubt any of the following circumstances? The question is, while in the structure, the defendant was armed with a firearm, yes or no. And then your last choice with regards to count 5 of the indictment is not guilty. If that's your verdict, you would check the line to the left. Then the foreperson would sign and date the verdict form below. Let's go on to the verdict for count 6 of the indictment, which reads as follows. We, the jury, find the defendant, James Terry Colley, Jr., as follows as to count 6 of the indictment. Again, it states in the italics, please choose only one as to count 6. Your first choice is guilty as charged of the crime of burglary contrary to Florida statute section 810.02, paren 1. If that's your verdict, you would check the line to the left, and if that's your verdict, there's an additional question for you to answer. Right below that, if you find the defendant guilty of burglary, do you also find beyond a reasonable doubt the following circumstance? The structure entered was a dwelling, yes or no. Your next choice with regards to count 6 is guilty of the lesser included crime of trespass in a structure contrary to Florida statute section 810.08. If that's your verdict, you would check the line to the left. And your last choice with regards to count 6 is not guilty, and if that's your verdict, you would check the line to the left. And then again below that, the foreperson would sign and date the verdict form. Now let me go to the final count of the indictment. This is count 7 of the indictment. Let me cover the verdict form for that. We, the jury, find the defendant, James Terry Colley, Jr., as follows as to count 7 of the indictment. And again, it states in the italics, please choose only one as to count 7. Your choices are as follows. Your first choice is guilty as charged of the crime of aggravated stalking after injunction, contrary to Florida statute section 784.048, paren 4. That plus you. If that's your verdict, you would check the line to the left. Your next choice is guilty of the lesser included crime of stalking, contrary to Florida statute section 784.048, paren 2. If that's your verdict, you would check the line to the left. And your last choice is not guilty. If that's your verdict, you would check the line to the left. And then again, the foreperson would sign and date the verdict form. So those are the verdict forms, folks. We'll continue with these instructions. We're almost done. Continuing on page 44, towards the bottom. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It's also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. I'm going to go off script here for a little bit just to mention one thing with regards to the foreperson. You may have noticed by now trials are not like the trials on television. On television, often the forepersons read the verdict out loud. We don't do that in real life. There'll be someone here in the court, another part of the courtroom staff that'll read it. So if anybody doesn't want to be the foreperson because you're concerned about that, don't be concerned about that. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communications such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. As I mentioned to you earlier, the rules do not allow you to bring your phones or any of these types of electronic devices into the jury room. So in a few moments, I'll talk a little bit more about that and leave them behind if you have them with you. And many of you probably left them in the cars this morning. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in that note. If you have questions, I'll talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it's important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Now, let me address a couple of things before we go back to deliberate. First of all, 2 of you have served as alternate jurors in this case. In just a moment, I will tell you who they are. The alternate jurors do not get to go back and deliberate a verdict at this point. Alternate jurors serve a very valuable role because in many cases, some of the, for lack of a better term, regular jurors, non-alternate jurors, are unable to serve and complete their jury duty, and the alternate jurors will slide into that position and be able to deliberate a verdict in the case. Because of the rules that we follow, I'm not allowed to tell you until this point who the alternate jurors are. The alternate jurors, I will have some instructions for you in just a moment after everybody else retires to deliberate. But the 2 folks who are not going to be able to deliberate a verdict in this case are Mr. Legacy and Ms. Sexton. You have been our alternate jurors. You've been sitting here for a week and a half, taking notes, listening very intently, but you're not going to be able to deliberate a verdict in this case, and I'll have some additional instructions for you on that after everybody else goes out. Now, before we broke yesterday, I mentioned that you were not going to be able to take your phones, tablets, and other devices with you back into the jury room, but realizing sometimes we forget to leave them in the cars. Everybody does. Does anybody have any such device that the deputies hold secure, or did everybody leave in the cars? Okay, great. I appreciate that, folks. All right, so what we're going to do is I'm going to have everybody except for Mr. Legacy and Ms. Sexton deliberate or retire to deliberate your verdict in this case. We'll have you deliberate, I think I mentioned it yesterday, in the jury lounge. There's a room off to the side that's a little larger than this room, so it gives you a little more room. We'll get the evidence brought down to you in just a couple of minutes. There'll be a computer also sent down to you if you want to listen or look at any of those discs that were entered into evidence. That computer will not connect to the internet, so please don't try. We'll probably take some breaks during your deliberations at about an hour and a half mark or so. Once you start deliberating, I have to keep you together as a jury. So when you take your breaks, fresh air breaks, you will all travel to a secure location right around the courthouse together. If there's any smokers, they can go off to the side if people don't want to be around smokers, but we'll keep you relatively together during deliberations. If you're still deliberating as we approach the lunch hour, I'll send a lunch menu into you, and with some notes on that, on how to complete the lunch menu. It's pretty self-explanatory. Just check whatever you want on the menu, just not everything on the menu. Believe it or not, we've had people do that. And then if there's any questions or you need to communicate with me for any reason, there will be deputies stationed outside of your room where you'll be deliberating at all times. So just let the deputy know. They'll get that information to me, and then I'll gather back up with the lawyers. And then when you've reached a verdict, after the foreperson has signed and dated the verdict form, let the deputy know. Don't give your verdict to the deputy, but just let the deputy know you've reached a verdict. We'll gather everybody up here, and then we'll bring you back up to the courtroom. All right, with that, everybody except for Mr. Lagasse and Ms. Sexton may now retire to deliberate your verdict. If you'll follow Mr. Gray, he'll walk us down there. Seated in the courtroom. All right, Mr. Lagasse and Ms. Sexton, you've been with us for a week and a half, and you're probably like, how come I don't get to go back there and deliberate? Although maybe you're happy, I don't know. She is. Well, you're not completely off the hook yet. I'll talk to you about that in just a moment, but sometimes I have jurors with us for a month and taking notes, and then they're told at the last minute that they're the alternate. And sometimes they cheer, and then other times they're disappointed. So I can understand there's mixed emotions on that. As I mentioned to you all, and as we discussed about during the jury selection process in this case, if the defendant is found guilty of first-degree murder, there'll be another part to this trial called the penalty phase. I know we talk a lot about that in jury selection. So normally at this stage of the trial, if it's any other type of case, to the alternate jurors, I would say, thank you for your service. You're now free to do whatever you want to do, talk to whoever you want about the case. That doesn't apply to you two. Because in the event your fellow jurors find the defendant guilty of first-degree murder, we will reconvene for a penalty phase next Monday. So don't make any plans for next week. I don't know what the jury's going to do, but don't make any plans for a trip out of town or anything like that now that you know you're the alternate jurors. Because there is the chance that we'll go into that phase of the trial. What I'm going to do is excuse you in just a few moments. And thank you for your service, obviously, for this portion of the trial, but we're not completely done with you. Plan on being back next Monday at 8:45, same time, same place. We'll give you a call. We'll have somebody from the clerk's office give you a call and let you know if there was a verdict of first-degree murder, and you'll have to come back, or if you don't have to come back. So we'll call you either way, but do plan on next week in the event that we do proceed to that portion of the trial. The admonition that I've been giving you all through this trial to not watch media coverage, listen to media coverage, read media coverage will remain in place until next week because you may have to come back. I will tell you this, in the last case of this type that I tried last year, one of the alternate jurors did have to step in during the second phase of the trial, so don't let your guard down and stop paying attention. I don't think you would, but alternate jurors do play a very valuable role in both phases of the trial if we have to go to a second phase. The same rule applies also with regards to not talking to anybody about the case and not doing any research about the case. And I know that's going to be tough because you're going to go home or back to work today And folks will immediately start asking you about the case and what you've been doing the last week and a half. And you're just going to have to resist and say, I'm under strict instructions from the judge to not discuss the case. Please don't talk to me about the case. Get away from me. If anybody here in the audience tries to, or anybody around the courthouse tries to talk to you about the case, please tell them to stop talking to you about the case and let one of the court deputies know immediately, and I'll deal with that issue. But what we're going to do is we'll secure your notes in the event you have to come back next week. Same thing with the jury instructions. One of our deputies will escort you down to get your bags that you brought in this morning, and also escort you out to the parking lot. And we will give you a call. I don't know when it's going to be. Obviously, I have no idea how long it's going to take for the jury to deliberate in this case. But as soon as there's a verdict, we'll give you a call and let you know what that verdict was, and we'll let you know that you need to be back next Monday. But plan on next Monday, 8:45 for scheduling purposes. And with that, I thank you, and may or may not see you next week.
Yeah.
Okay.
Y'all
Just got it.
y'all are there in
Y'all receive it. We need to make edits to the verdict form on counts. It was only counts 3 and 4, correct?
Oh, there's two places on the
Right. On count 3, I'll go into the case. Yeah. On count 3, the sub-question, I'll insert the word attempted in front of the word manslaughter. And on count 3 for the lesser included of attempted aggravated battery, on the sub-question, where it says attempted second-degree murder, I will cross through that and insert the words aggravated battery. And I'll do the same thing with regards to count 4. All right. Y'all want to look at those just to be sure?
Yes, sir. If I can just, for my thoughts, just have a copy of that.
We'll get you a copy somehow. Okay, any exceptions or objections to the final instructions as written?
There you go.
Okay, we'll be in recess until we hear from the jury. Don't stray far. And if there's any questions, we'll let you know.
The the newest version from May of this year in those objections or edits. I'm assuming the grounds for Dr. Bobbitt will be as stated in your previous motion, when you just said it would be requested to be applicable to penalty phase. I'll edit or modify my response to that. There may be a couple other motions that will be filing to motions eliminated regarding certain issues that I could foresee from the state's penalty phase witnesses. I don't want any mention. I think they may try to come out with testimony based on some testing that was done by Dr. Mills on the MMPI regarding some testing for anger issues. That will not be something that will come up in the defense case and penalty phase, so I think it'll be irrelevant, obviously unduly prejudicial. Also, this is an issue that can kind of morph from that, which is an argument that comes out from a witness of alleged future dangerousness, which is highly prejudicial and inapplicable and inadmissible in a penalty phase proceeding. That might be something that Dr. Danziger tries to get into, or Dr. Goldberger, and those are two state's witnesses. So I'll have, by the end of the day, probably a couple of motions on that issue. That's what I have so far, kind of those general things. Certainly, if you want to maybe meet like maybe Friday morning.
You were reading my mind. That's where I was going with that.
Okay.
Okay, Friday morning work for y'all?
Yes, sir.
It does. I presume you have the week blocked off. All right, let's do this. In the event there's a first-degree murder conviction or verdict, and we have to move on to a penalty phase, let's meet Friday morning at 9 o'clock. I'll ask the state prepare a set of jury instructions for the penalty phase, as well as proposed verdict forms. I do plan on following what the Supreme Court said to do on the verdict form. I don't hear any argument to the contrary on the issue of mitigation, but prepare your verdict forms with the understanding that I intend to follow what the appellate courts tell me to do. And we can address those issues at that point. Do you have a list of your enumerated and non-enumerated mitigators that you're going to be?
I have a draft. I want to have some further discussions about that, not only because it's important for the obvious reason, but as you were actually alluding to earlier, there's an issue about on the verdict form how mitigating circumstances are dealt with, whether there's going to be polling. Justice Pariente, in a concurring opinion, made that comment and advised that. So
they'll need to be addressed in the final instructions during the penalty phase.
Yes.
So
yes, sir.
That's why we'll need a list at some point.
Yes.
And sometimes that can be lengthy.
And usually the way, at least the way I've dealt with it in the past, we try to make sure that we've got an accurate list of mitigating circumstances from the get-go. But it's not unusual that something comes out that we need to edit or make an addition or that sort of thing during the course of the penalty phase.
And with word processors, that's easy to do.
Okay.
So let's plan on Monday morning at 9 o'clock if we have to have a penalty.
And then Friday morning for...
That's what I meant. I'm sorry. Friday morning at 9 o'clock. Monday would be 8:45.
Yes,
Thank
sir.
you for correcting. Okay. And we'll be in recess until we hear from the jury.
Thank you, Judge.